Hey everyone, this is Mike DeBliss. This is part 2 of the podcast on nuts and bolts of internet copyright law. I'm going to pick up from where we left off in the first part of the series, and that is, what are the DMCA procedures? Just to recap, DMCA stands for the Digital Millennium Copyright Act. And what we're talking about here is content that the content creator created and put out there on the internet, and that has been taken by a third party without the creator's permission or consent. And so the Digital Millennium Copyright Act can be used to force the black hatter, if you will, to take down the infringed content. However, the DMC procedures are a bit cumbersome, and this can get expensive. So what tends to happen, and this is the cadence or the dance, so to speak, that takes place, is that when the content creator realizes that his or her content has been taken by a black hatter without their permission, they usually go to an attorney. And what the attorney recommends is, before we even get to the DMCA takedown procedures, the attorney will recommend sending a cease and desist letter to the offending party. And paraphrasing, the letter usually says something like this, quote, "I am John Doe. I represent Michael Smith, the copyright owner of this course, if it's a course, or this ebook, if it's an ebook. It has come to our attention that you are selling Mr. Smith's course or ebook in an unauthorized manner." The lawyer would then demand that the infringing party remove the content immediately and cease using it. And as a way to put some teeth in that letter, the attorney will probably add what the potential damages are that the infringer would face if found liable in court. And that cease and desist letter goes a long way and is usually enough to do the trick. But let us suppose that we hear crickets in the wake of sending that cease and desist letter. So let's move on to the DMCA procedures, because they are specifically designed to assist the content creator in enforcing his or her copyright and in getting the black hatter to remove the content. The first step is to basically request that the page or that the offensive or infringed upon content be taken down. And this is done through what's called a takedown notice. All a takedown notice is a document that says that the site is infringing on a copyright owner's copyright. An important issue that arises when it comes to a takedown notice is who to serve notice on. I know that sounds a bit elementary, and one would think, well, of course it should be obvious, but this can become a little bit complicated in the legal realm. So here's what I recommend. I recommend that the client send the notice to the site owner first, the one who has taken the content without the content creator's permission, and give them a chance to remove the offensive content. The reason is that in some cases, the site owner is not at fault. For example, the site owner may have hired a freelancer on maybe Upwork or some other freelance platform to build the site, and unbeknownst to them, the freelancer may have used copyrighted content such as stock images. In that case, the site owner is usually apologetic because he or she didn't know that the freelancer used copyrighted content and is quick to remove the content immediately. But let's suppose you hear nothing but crickets, not critics, after serving the takedown notice on the site owner. What's the next step? Well, the next step is to track down the host and send the host company a DMCA takedown notice. Now, just to put this into context and so we are all on the same page, what I mean when I say host is the company that is hosting the website. It could be GoDaddy. It could be HostGator. It could be any one of a number of different hosts, Bluehost, that's out there that host websites. These hosts host thousands and thousands of websites. And so they are very familiar with the DMCA procedures and do their level best to stay in compliance with the DMCA procedures, because if they don't enjoy the immunity that comes from the safe harbor provision. So the next course of action, if you hear nothing but crickets from the website that has taken your content, is to serve a takedown notice on the site owner. Now, logically, we're not going to know who the host company is until we do some due diligence of our own. So we have to track down the host and send the host company the DMCA takedown notice. The host company usually responds by removing the content, since the way they guarantee immunity from lawsuits and shield themselves from liability for content uploaded by their users is by complying with the DMCA compliance process. Now, note that the individual who posted the infringed content may still be found liable. And so what we're going through here is a process of being detective and searching to find who the host company is of the website that has stolen or pirated the content. And there are ways of doing that we're going to get into as we go through this podcast. But for now, there are a number of reasons that hosts have a vested interest in getting rid of repeat offenders. I've mentioned one at the top, that in order to enjoy the immunity that's guaranteed to them through the safe harbor provision, they have to have a firm compliance process in place, and they have to be following it. So it's not enough that they can show the DMCA regulators that they have a compliance process in effect. They have to show that they're following it to a T. And so here are some other reasons why these hosts have a vested interest in getting rid of repeat offenders. Hosting companies like GoDaddy host thousands of websites, so they understand the DMCA upside down, backwards, and sideways. Second, a large hosting company like GoDaddy or Bluehost isn't going to risk being shut down so that, just because of one rogue website owner. All right, they have thousands and thousands of websites that they host, and so they're not going to risk going out of business in order to protect one rogue website and allow them to continue operating. So they're often quick to react in the wake of receiving a DMCA takedown notice. And finally, maintaining their reputation is very important to them. Companies like GoDaddy don't want bad publicity because, of course, there are people that are starting websites all the time, and they want to be able to attract new business, and they don't want people to avoid them like the plague. And so for that reason, their reputation is very important to them. So let's get into the weeds about what information has to be included in a takedown notice? A takedown notice usually consists of 5 key elements. The first is that it's necessary to identify the URL where the infringing material appears. So essentially, you find the page where the copied material has been uploaded. You want to basically extract the URL and include that in the DMCA takedown notice so that you're referring the host, or you're referring the website owner for that matter, directly to the page on the website where the infringing material appears. Second, you need to identify the URL from your site where the original content appears. Very, very, very important. You can't leave that out. You can't make a bald-faced claim that a website has infringed upon your material without showing the site owner and the host company where it exists on your website. And I might also add, when you are dealing with identifying the URL from your site where the original content appears, I would recommend, if it's a blog on WordPress, to provide in the takedown notice the timestamp that the content was published on that page. And the reason I say this is because it's important to establish that your content came first. Otherwise, you could have the black hatter turn around and say, hey, this content is my content. I created it. It's original, and I posted it on my blog or on my website before you did. And so to avoid any type of frivolous arguments like that, you want to nip it in the bud right away and do so in the takedown notice so that there are no leaky holes and there are no escape hatches, so to speak, for the black hatter to make a scurrilous argument in opposition to your takedown notice in their response. So part and parcel of identifying the URL from your site where the original content appears, I strongly recommend providing the timestamp from the WordPress site that establishes the exact date and time that you published your original content. And I'm assuming here, for the sake of argument, that it is original content, it's yours, and it's been stolen, pirated, whatever vernacular you want to use by a black hatter. The third element that a takedown notice must include is a statement under penalty of perjury that you have a good faith belief that the infringing party has no right to the content. It's basically a statement, and under penalty of perjury means that you're not lying about this and that this is truly your content and that this black hatter had absolutely no right whatsoever to take your content. And so here is where you want to be very careful. If you are engaged in some type of agreement with affiliates, and you've created an online course, and you have given the right to a number of affiliates to publish your course on their website, you want to be 100% sure that this person who you are accusing is not one of the affiliates that have signed an agreement with you and that you are leasing your course to, so to speak. And I say this because the backlash could be a perjury claim against you. So as obvious or as sophomoric as this might appear, you want to do your due diligence before you start pointing the finger at someone and accusing them of taking your content because it could come back and bite you in the butt. Fourth element of a takedown notice is another declaration under penalty of perjury that you are authorized to submit this takedown. What this means is that you are an authorized agent or you're the person that owns the copyright. We'll get into that a little bit more. But for purposes of illustrating this point, if you created the online course or content yourself, you're considered the owner of the copyright. And finally, the last element that a takedown notice must consist of is you signing the notice by saying, "I hereby sign the notice." What happens once the takedown notice is submitted? The content must be removed immediately. There are no ifs, ands, or buts about it. It's not about looking at it and saying, well, there are some defenses that might exist. It has to come down. As soon as the agent receives the takedown notice, or the black hatter, so to speak, receives a takedown notice, it must be taken down. Again, there is no discretion whatsoever. This is a blanket requirement of the statute. It must be removed. Now here, it's important to distinguish between the page or pages that contain the stolen content and the entire site. What I mean by it has to be removed is that only the pages that contain the infringed content have to be removed, not the entire site. And so there's a distinction here that has to be made. The plug does not get pulled on the site altogether. It's merely the offensive content. Now, I made one assumption here. I made the assumption that a page is analogous to that a page contains all of the pirated content. That may not be the case. A page of the website, of the Black Hatter's website, may only contain 1/4 of stolen content. Well, in that case, that 1/4 would have to be removed and not necessarily the entire page. But when you deal with the DMCA statute, and out of an abundance of caution, most hosts are going to remove the page, all that contains the infringed upon content altogether. So to rephrase, a DMCA takedown notice requires only the stolen content to be removed, not the entire site to be banished from the annals of cyberspace. There are two situations that arise depending on whether the infringer is a site owner who outright stole the content or instead a user of the website who posted infringed content on the website. So the 2 points here are this. First, if the scenario is one where the infringed content was user-generated, the site owner must remove it immediately. And what we're talking about here is a situation when a Facebook user posts, say, a copyrighted cartoon or photograph from a magazine, an online magazine or a paper magazine on their Facebook page. Facebook must remove the cartoon or photograph. And again, they are incentivized to do that in order to take advantage of the safe harbor provision that immunizes them from being named as a secondary tortfeasor in any type of legal action. Second, if the scenario is one where the site owner stole the content directly and the site owner does not remove the infringed content upon submission of the takedown notice, you want to hunt down their host. And this is where I get into a little bit more detail about how you would go about doing that. You can conduct a WHOLS search for the domain, for their domain, and then look through the domain listing. The domain listing often lists the hosts. If you find the host, you would then submit the DMCA takedown to the host. Under the DMCA rules, the host enjoys immunity from all claims so long as they have been adhering to the compliance process. And one of the compliance factors in that process consists of keeping a list of repeat infringers. As this name suggests, repeat infringers are individuals who have racked up a number of complaints. Repeat infringers risk having their entire site taken down and their account canceled. So this is the situation that I alluded to earlier, where the plug is basically pulled out and their site goes down, and that is it for them. Now, I mentioned that a repeat infringer is one who has racked up a number of complaints. Well, believe it or not, the number of complaints required before a host resorts to this draconian measure is staggeringly low. It doesn't number even in the double digits. It could be as few as 2 to 3 a year. The host has the discretion to set its own policy. So again, this is very favorable to somebody who has had their content stolen, because it's not unusual for the black hatter to have been doing this against other innocent parties in addition to you. So it's important for the host company to keep track of the repeat infringers and to keep a list. And as I mentioned, this is part of one of the factors that has to be built into the compliance procedures, and that's required by the DMCA. Practically speaking, when you send a DMCA takedown notice to the host of the infringing website, the host, again, this is GoDaddy, Bluehost, any one of the big hosting companies, HostGator, the host has to do one of two things. First, they automatically take down the page that contains the infringing content if the entire page consists of it, or if a small part of the page contains the stolen content, then it would be that part that gets removed. But again, out of an abundance of caution, the host usually takes down the entire page. Second, the host will send the site owner a notice, and that notice usually says something to the effect of, we just received a copyright infringement complaint, we're going to remove the content in 2 days, and you need to respond. In the vast majority of cases, the website owner has no justification for using the content and the host removes it. But what about the rare case where the website claims to have a right to use the content? Well, if they assert a claim to have a right to use the content, they would then advise the host and draft what's called a counter notice, which is just a fancy legal term of saying a response to the takedown notice that was served on the host and them by the original creator. And again, the counter notice serves as a response to the DMCA takedown notice. The host would then send the counter notice that's drafted by the website owner, in addition to pedigree information about the site owner, to the okay, let me back up for a second. The host, would then send the counter notice in addition to pedigree information about the site owner, like their name and address, to the copyright owner or to the agent who submitted the takedown notice. All right, so the host is basically acting as the go-between here in terms of transferring, or in terms of submitting the counter notice from the website owner to the copyright owner or to the agent who submitted the takedown notice. The copyright owner, the one who initiated the lawsuit, or the one who initiated the takedown process, then has between 10 and 14 business days to file a copyright infringement lawsuit against the infringing party in federal court. So as you can see here, we have some hard and fast deadlines that are coming into fruition. And I want to just go back to make this as clear as I possibly can, because I'm afraid that I might have made it very murky before. In the rare case where the site claims to have a right to use the content, what they would do is they would draft a counter notice, and they would advise the host, because it's usually the host that advises them that they've received a takedown notice and that they have to respond, and that they have 2 days to respond to the request. Otherwise, the host is going to remove the page that contains the infringed content. In the rare case where the website claims to have a right to use the content, they would have to advise the host and draft a counter notice. And that counter notice serves as a response to the DMCA takedown notice. The host then forwards that counter notice, in addition to pedigree information about the site owner, to the copyright owner or to the agent who submitted the takedown notice on behalf of the copyright owner. It might have been either or, because the copyright owner may have assigned an agent to submit the takedown notice. The copyright owner then has between 10 and 14 business days to file a copyright infringement lawsuit against the infringing party in federal court. And here's what happens. This is how strict this 10 to 14 business day timeline is. If the copyright holder doesn't respond within 10 to 14 days after receiving the counter notice from the alleged black hatter, the agent will republish the content. The copyright holder here, and one might ask, well, why wouldn't the copyright holder respond within 10 to 14 days to a counter notice? Well, the reason being is because this can get very, very expensive. And the copyright holder faces a strategic decision between going through the incredibly expensive and daunting process of filing a copyright infringement case in federal court, or dropping it altogether. To the extent that the copyright holder files an infringement case in federal court, they would file it against the person who posted the infringed content and not against the site owner, because the site owner is protected. The DMCA guarantees immunity to the site owner. So what I say to all of this is this. This is this process can become complicated and expensive very fast. But what I'm doing here is I'm taking you through the entire process. And in the vast majority of cases where the DMCA takedown notice is served on the host, this usually ends the matter once and for all. So again, it's a rare case where the infringing party would actually respond by filing a counter notice, because they're usually dead to rights wrong, and they usually respond to the takedown notice by removing the content, or if they don't respond, the host usually does it for them and removes the content, and that usually ends the matter once and for all. This is only if we get to the final stage where the black hatter alleges some type of claim to the material and submits a counter notice in response to the DMCA takedown notice. That's where the copyright holder faces this strategic decision between going through the lengthy and expensive process of filing the copyright infringement case in federal court or dropping it altogether. And again, it's very important to recognize here that to the extent that the copyright holder files an infringement case in federal court, they would file it against the person who posted the content, the user, if it's a user, say, on Facebook, and not against the site owner, say, for example, Facebook, because they enjoy immunity under the safe harbor provision. Again, the DMC guarantees that immunity to the site owner. Now, what happens if the website is hosted by a company located outside of the United States, such as in Russia or in the Czech Republic or any one of a number of other countries? Recall that the DMCA is U.S. law. And so while before we had no response from the site owner and we escalated the matter to the host company, we're now in a situation where the website is hosted by a company located offshore, and the DMCA that is meant to protect us is U.S. law. So the issue becomes one of, is there a way to extend the reach of the DMCA to a foreign host that is located offshore? Now, the U.S. has treaties with foreign countries to enforce its laws, and these treaties usually tend to exist in the tax realm. For example, there is a act called the Foreign Account Tax Compliance Act, which the U.S. government relies upon to obtain information about U.S. account holders who may be possessing foreign bank accounts with banks in, say, Switzerland or in other parts of the world. The IRS, as you can imagine, has a vested interest in knowing about these accounts, because if they have gone unreported, then that means that the taxpayer is in violation of their tax obligations to report the accounts on a form called FBAR and to disclose any interest income that's generated by those accounts, and to report that on their 1040 and pay taxes on that interest income. So that's one of the applications of a tax treaty in the realm of tax law that the government has with foreign countries. But the U.S. also has copyright treaties with foreign countries. Now, before you get too excited and start jumping up and down that DMCA can be used or executed against a foreign entity, it's important through a treaty. It's important to recognize that to enforce a foreign treaty against an offshore host would be very time-consuming and expensive. And this is exactly why black hat websites make use of offshore hosts. An alternate strategy would be to determine whether the site uses any domestic payment processors. And by domestic payment processors, what I'm referring to here is companies like Venmo or PayPal. If so, you can lean on the payment processors just like you leaned on domestic hosts like GoDaddy. Because these payment processors are U.S. companies, you could theoretically serve a takedown notice on PayPal, and PayPal would have to cancel the account of the infringing website and seize whatever money was in the account. Now, if the black hatter doesn't have any U.S. payment processors, there is yet another option that you could pursue, and that involves looking to see if the black hat website is promoting any U.S. affiliate sites. If so, you could send a notice to the affiliate sites as well and advise them that this website is infringing upon your content, and they too will often act. The good thing here, and all of this goes to the point that the U.S. is a global marketplace, not unlike every other country these days. However, the U.S. basically stands alone in the fact that it is global on a magnitude unlike any other country. And so there's a strong likelihood that offshore websites will be doing business with the U.S. in one form or another. However, we always have to take into consideration the worst case scenario where everyone is offshore, from the host to the payment processor to the site itself. What do you do in that case? Well, you can try to cut off the website's traffic by submitting a DMCA takedown notice to major search engines like Google, Yahoo, any one of those search engines. This may result in the search engine removing the link to the stolen content. And the idea here is that if you can get rid of the search engine traffic, you might be able to starve the site to death, like a leech that is basically, sucking the life out of its prey. And so that is an alternative strategy, although I would caution that it's difficult to get a response from Google and for Google to jump to action and remove the websites right away. I've heard of situations where it's happened, but it usually takes a long time. And with big Goliaths like Google, they don't have as much incentive to jump as quickly and react as the hosting companies do, like the GoDaddies and the HostGators. Now, once again, I want to emphasize that if you find the DMCA takedown procedures to be daunting, don't fear. Most attorneys do not resort to them until they have sent a cease and desist letter on the Black Hatter. I've basically paraphrased what these letters usually consist of. It consists of a bit of a bit of coercion on the part of the lawyer, because the lawyer wants to put teeth in the letter so that the Black Hatter doesn't throw caution to the wind and and shrug it off. He or she wants to get the full attention of the Black Hatter and compel them to remove the content immediately. And so what lawyers often include is what the potential damages are that the infringer faces, and stress that the content was posted or uploaded in an unauthorized manner without the permission or consent of the attorney's client. And again, a little bit of guilting along the way is par for the court, and this is usually enough to do the trick and is a lot less expensive than getting involved with the DMCA takedown procedures. Now, I mentioned earlier about when you submit the takedown notice, about submitting some proof that the content is original and was published on your website before it was published on the Black Hatter's website. And so there's a first-in-time requirement that I would encourage you to embrace. And the way that can be established is by simply printing out the timestamp from your WordPress blog, if it's a blog, that memorializes the date when the content was published. If you go to your WordPress site, if it is a WordPress site, and I'm sure that other websites as well contain the same feature, it often contains a timestamp that memorializes the date when the content was published. A screenshot of that timestamp would be sufficient to prove that your content has been published before the copied version, and you would want to include that in the takedown notice. And as elementary as this might sound, I also encourage clients to confirm that there's no legal basis for the infringer to use the content. In other words, that they had no authorization or permission for using the content, and that there is no kind of verified use for it. And I do this in no way to be, to be second guessing the client or to question their judgment for asserting such a claim. I want to make sure that all escape hatches are closed because, as I mentioned before, these statements and declarations in the takedown notice are being made under perjury, under the possibility of perjury. In other words, you are at risk for a claim that you have perjured the person that you are pointing the finger at if there is any type, if these allegations that you are asserting are false. So it's very important to do some due diligence up front and to make sure that that you have a good faith belief that the infringing party has no right to the content before you submit the takedown notice. And as I said, you don't want to be caught in the crosshairs of a perjury claim because that is a criminal action. Now, in the next part of the podcast, I'm going to talk about what you can do to reduce the risk of your content being stolen so that you position yourself in the safest place possible.